All right, we have brought in an outstanding lineup of speakers for today's event, with presentations covering a variety of topics and issues in the fields of estate planning and community property law, as well as related legal topics. So without further ado, let's get started. All right, our first speaker of the day is Ms. Sarah Pacheco. Ms. Pacheco is a shareholder with the law firm of Crain, Caton, and James, P.C. in Houston, Texas. She received her law degree from SMU in Dallas, Texas. Her practice is generally limited to litigation, administration, and tax issues relating to estate, trust, guardianship, and related fiduciary appointments. Ms. Pacheco is board certified in estate planning and probate law by the Texas Board of Legal Specialization. She is a co-author of West's Publishing's Texas Probate Practice Guide and West Publishing's Texas Wills, Trusts, and Estate Planning Practice Guide, and the editor of the second edition of the State Bar of Texas's Guardianship Manual. She's been named as one of the best lawyers in America in the practice areas of trusts and estates annually since 2006, and in litigation with trusts and estates annually since 2012. Most recently, she was named as Best Lawyers 2014 Houston Litigation Trust and Estates Lawyer of the Year. Ms. Pacheco's presentation today is titled 2014 Guardianship Update. Ladies and gentlemen, it is my pleasure to introduce our first speaker, Ms. Sarah Pacheco.
Thank you, Ashley. Well, good morning, everyone. It's nothing like being the first speaker after a few cocktails the night before, so I will try and do my best to make sure I stay awake and you stay awake. Before I begin, I will defend everybody on the back row because that's where I like to sit also. I feel like that way I can take in the whole picture of the law, so I know how you guys are doing back there. Among those in the back row is my colleague, Chastity Thomas, who's hiding down there in the red sweater. I just wanted to tell her I appreciate her co-authoring this article with me and recognize her contributions to it. Well, let's get started. I always say legislative updates are sort of a summary of what the courts and the legislator have done for you, to you, and that other category that, since we're on tape, we will not articulate in this very nice setting. So as we get going, what I've done is I've categorized the paper into statutory updates, rule updates, case law updates, and then a reminder that we do have new pattern jury charges in the guardianship area. We've never had those before, and so I just wanted to point those out to you as we get to that part. Let's start with the statutory updates. This is breaking news. We have an estates code. We've all learned to love the estates code in the 2 months that we've now had the estates code. And we can't really complain. The legislature gave us lots of warning of the estates code. They told us 50 years we were going to eventually have an estates code. But we know in probate and trust and guardianship matters, things really don't happen very quickly. So in 1963, they said we have to do this. In 2007 and 2009, we actually enacted it. And today, as of January 1st of this year, we actually have to apply it. But that didn't mean we all didn't lament on January 2nd of this year, and I'm sure some of you did too, how we're going to correlate the new estates code to the old probate code. Thanks to Jerry Beyer, we can at least find the right sections, and I do appreciate his and everybody's contributions in creating that conversion chart. In terms of the estates code, just like the probate code, it includes all the guardianship sections. The guardianship section, which used to be Chapter 13 under the probate code, has now become the 1,000 up in the estates code. So that's where you're going to find all those sections. It's not shocking that they have an effective dates on the estates code. Likewise, breaking news, the estates code or the guardianship sections apply to guardianships filed before the estates code was enacted and filed after the estates code enacted. But we have a long section that tells us exactly how that applies, and it's on the page 1 of your paper. One point I would make is there is a very few exceptions to the application of the estates codes to certain things like management. We used to call them 867 trusts. Now we just call them management trust. There is some parts of those that are not applicable if the trust was created prior to the effective date. And that goes to because we're changing some of the administration provisions, and we're not going to do that to trustees unless there's a modification of it. So I point that out to you. Other new statutory changes beyond the enactment of the estates code, starting on page just 2 of the paper, And I think this is an important change. In the past, there was a definition of guardianship proceedings, and there was a definition of management matters relating to guardianship proceedings. Those, again, of course, are in the state's code, but the definition of guardianship proceedings has fundamentally changed. It's been enhanced. Why is that important, other than it's nice to have a long laundry list of definitions? I mean, things that are now clearly in it are not just things relating to guardianship, but applications, petitions, mental health issues, modifications. Those are now more clearly defined. Why does that matter? Because the jurisdiction sections in the estates code are tied to this definition. And there's a recent case we'll talk about in a minute which talks about guardianship proceedings. The jurisdiction is exclusive to the court that has jurisdiction over that guardianship proceeding. So you don't get to say, well, maybe I'll do my guardianship here and some other things over here necessarily. It more clearly defines, when you tie the two sections together, the exclusiveness, the exclusive jurisdiction of a court governing a guardianship proceeding. And that becomes important when you start getting to litigation where the guardian is a party, as we'll see in a case in a minute. The definition of guardianship matters is set out on page 2, the new definition, and you'll see there's a difference between when you have a statutory probate court and when you don't have a statutory probate court. Most of the larger communities have been able to get through the legislature statutory probate courts. I don't believe there's one out here yet, but as the population grows, it's all based on populations and counties. But statutory probate courts in Fort Worth, Dallas, San Antonio, Austin, Collin County, Denton, Houston, Galveston, and El Paso have the ability to basically have jurisdiction equal to district courts. So there's hardly anything they can't hear in that court because they have the underlying jurisdiction of a district court, and therefore they have expanded that and made sure that their jurisdiction as it's defined to matters relating to guardianship proceeding are equally expanded in this section. This section is very similar to the old section, but again, because of this new case, you can see this is sort of a roadmap to you of what other jurisdiction does my court have that's hearing the guardianship if it's not just the application and the administration of that guardianship. We added a new section to clarify that certain aspects of the Texas Rules of Civil Procedure do not apply to guardianship. There is a general section in the Estates Code that says that the Texas Rules of Civil Procedure apply in guardianship and estate proceedings unless there's exclusion. This is one of those exclusions. And it's pretty simple, really, what we've excluded. We've pretty much incorporated every rule of civil procedure with the exception of new expedited trials, which doesn't really apply in the context of what those are intended to do. And the fact you don't have to plead for monetary relief, well, we're talking about a guardianship. Generally, it is not pleading for monetary relief. So those are really the only exclusions that when you look these sections up, that's what they're talking about. So what's the default of this? Pretty much all your rules of civil procedure in terms of discovery and other things apply in the same way in a guardianship proceeding, then it's going to be in your general civil litigation. Other new sections of note, the information letter. We used to be able to just write a letter to the court. It was called a 683 letter under the old sections, where somebody could say, I don't really want to apply for guardianship. I don't want to get into all that. I just want to tell you about Mr. Smith or Mrs. Smith. She's having problems, and I think somebody should look into it. Well, the problem is every good intention can get contorted or misused. And people started writing these letters to the court, and courts were having to investigate, and sometimes it was because they didn't like Mr. Smith, and they thought he was a little loony because they wouldn't sell him his land or they wouldn't do this. So they made it a little, and then you got into the divorce context. So now they've made it a little bit more stringent. One, they talk about an interested person writing this letter, which is still a very broad definition of individuals. But also, if it's written by a family member, that person now has to swear to that, and so they have a higher level of responsibility in terms of signing what they believe the person is believed to be incapacitated. And those requirements are on page 6 of the paper. Let's talk about confidentiality of certain information for a minute. You know, we have, obviously, everybody here knows that the misuse of personal information has led to a lot of identity thefts. A couple of years ago, Texas enacted under the Business and Commerce Code a general identity theft section, which includes applying to businesses such as lawyers and law firms. it makes us have to be very careful with the information we receive, how we store it, how we dispose of it. That idea continues to be incorporated in all aspects of the law, and most recently it was incorporated into the estates codes in the guardianship section to make sure when you're filing applications or you're doing things, and it's very applicable to our section or our proceedings, because think about how much financial information we have, how much medical information we're required to show the court. But be careful when you file it. Make sure that there's not certain information in there, identifying information. If you have to redact, you should redact, because not only do we have these sections that say it, we have another section that's existed for a few years in Business and Commerce Code that puts obligations on businesses. We're in that definition that if we release inadvertently that information. So now we have to make sure we don't include some of that information. I'm not sure we have to have a law for this other than it's just common sense, but now it says in the guardianship sections, bottom of page 6, you'll see anybody protected by a protective order does not have to necessarily file the address, phone number, place of employment, those type of pieces of information, school attended by a child, and it says a court may grant it. I would certainly hope a court would grant it without this law, but if you need clear authority, you now have it in the guardianship code. Let's turn, next new section deals with the appointment of attorney ad litem. Every guardianship proceeding requires a lawyer to represent the proposed ward, and in some cases, the ward. That title of that job is attorney ad litem. I'm sure many of you have been in that role in the past. It is generally a court appointee that the court selects to make sure the individual has a good lawyer that's completed the certifications. Well, Section 1054 provides a laundry list, just to be clear, of all the provisions where a court may appoint an attorney ad litem. And you'll see it's not always now for just the proposed ward. It may be for a non-resident. There may be others involved. So this section is in the guardianship code, to be clear. But the next section is more important. It's the ward selection of counsel. Because the rub has been since, gosh, as long as I've been appointed a lawyer, that there's proposed wards that have some level of capacity. And they just don't want to take the lawyer the court has appointed. They want to pick their lawyer. In a sense, it's their vestige of speaking for themselves. The law is now clear that the court can allow the proposed ward to substitute his or her selected lawyer in as his or her attorney ad litem instead of just picking or accepting the person the court appointed for him. That's the easy part. The hard part is, in order for the ward or proposed ward to get their lawyer, they have to prove they have capacity. Well, that's kind of the core of most guardianship proceedings. So it's going to be a tough situation for anybody to invoke this provision. I think the intention was right, but the threshold is so high, it's going to be very difficult to meet it for the court to find they have the power to contract, because that power is usually on the higher scale of executive functioning. And so if they have that, the question is going to be why are they going to go forward with the guardianship at all? But maybe the legislator thought they didn't take a whole lot of capacity to hire a lawyer. I'm not sure what they were thinking at the time. Just to point out, we now have a change in the term mental retardation. We have modernized it to intellectual disabilities. That is reflected now in the code throughout. Another aspect of that is if you have an individual that you're seeking a guardianship for because they have a child or a family member with an intellectual disability, the period of time you can use medical is much longer now. It can be 24 months. It used to be much more expedited, meaning shorter time period between filing and medical. So I point that out. I want to talk about disqualified persons because I think this is just great. I think we need a law for this. You'll be happy to know that no longer a person is qualified to serve as guardian if they've been convicted of a terrorist threat or they have been convicted of continued violence against the family of the ward or the incapacitated person. This is one of those that do we really need a statute that says that if somebody has been convicted of a terrorist threat against the ward, they should not be that person's guardian. But we have one in case that is your case. Okay, let's switch over to mediation. I'm a big proponent of mediation. I think one of the hardest places to mediate a case is in a guardianship. If any of you have done it, you know. I mean, how do you go to somebody and kind of mediate their incapacity? But It's a huge tool. It's work because we've got lots of options in terms of not doing a guardianship if they'll just do this or trust somebody else. But when we enacted a new section finally on mediation, it's the first one we've ever had, we adopted a family law type section. So those of you in family law know that in family law cases, you can enter into an irrevocable settlement agreement that you're entitled to go get judgment on. That's unusual because in all other litigations, you can enter into settlement agreements and Rule 11s, but if the party wants to withdraw their consent prior to going to judgment, the court cannot just go enter an agreed judgment on that. It's a breach of contract case. Well, we've enacted this section which very much parallels the family court section, family code section, but the caveat is there is an out in this. I don't think it allows, once the parties sign, if they meet the requirements of this section, which is you have to have big, bold letters that say it's irrevocable, the party and if his or her lawyers there both have to sign, again mirroring the other sections in the family area. But the court can agree not to enter the agreement if they find the agreement is not in the best interest of the ward. But that's not an out for all the parties. That's just an out for an attorney ad litem or somebody along those lines. So you have to be careful if you go to mediation and you sign one of these deals that your client understands he or her may not have the ability to walk it later and just deal with it on a breach of contract basis. Next section, notice to peace officers in order of guardianships. I've just copied the whole new section in my outline. There is now a big, bold provision in the Estates Code that you are to put or should put in your order appointing guardians. The purpose of this was in the past, not every peace officer understood what the authority of a guardian was. So if you have a guardian of the person and somebody's interfering with that authority, sometimes the peace officer really wouldn't be able to do something on the instruction of the guardian of the person because they really were uncomfortable as to the extent of that person's powers. So if you have a guardian of the person, you should be inserting these new provisions. It's essentially an instruction to the peace officer, it's okay, you should do this. And it's also an instruction to third parties, if you interfere, you can be fined up to $10,000. And it really can be very helpful in the situation of placement, interference with residency, all those kind of things. Payments of legal fees and costs, I just want to point out there's some new sections in regards to that. Historically, and we'll talk about in a minute, there's cases all over the place on, how if you interfere with a guardianship or you contest a guardianship or you bring a guardianship, under exactly what circumstances are you entitled to have reimbursement or payment of your legal fees and expenses out of the ward or proposed ward's estate. We have provisions in the code about security for costs. But over time, the cases have so narrowed those down that really the only way you can get security for costs under the sort of hybrided different Court of Appeals decisions cobbled together is if a court investigator says you don't need a guardian or the proposed ward doesn't need a guardian, and they continue on. So because of that, they added a new section in part to make clear that a court does have a mechanism to get fees and expenses paid or reimbursed to the proposed ward's estate if somebody does something they feel is not in good faith and with just cause. So we've essentially incorporated in the new sections an almost a Rule 13 type standard that allows the court to sanction, they don't call it that, but they can sanction essentially these individuals and get reimbursement of the proposed ward's fees or different fees if they are not maintained, if they acted in bad faith or without just cause is the standard. The other thing that's of note is in seeking your fees, assume you go forward, you get a guardianship, but in seeking those fees, the court now has an equitable and just standard, not just a reasonable and necessary standard, because they may find yes, the fees were reasonable and necessary, but based on the extent of the estate or the proposed ward's assets, it wouldn't be equitable or just in some situations to pay all those fees. So now keep in mind you have two standards, a reasonable and necessary, which is always the standard on legal fees, and also this additional new implant in the code of equitable and just. A couple others, and then I'm going to talk about cases quickly. We have the ability in guardianship proceedings to do estate planning. You'll remember we have that section, now it's 1162, but the point of it is we have the ability, if a ward has a lot of money and can't do planning for themselves, to go to the court and advocate for an estate plan, perhaps additional gifting, even taxable gifting, to utilize exemptions and things along the way. The problem is that's fine when they have a lot of money. There wasn't anything in the code to allow us to give away certain assets to allow them to get governmental benefits. So we have now amended that section to not only be concerned about estate and gift taxes, but also the ability to give away property for purposes of getting governmental benefits. The code says you can just do enough to allow for them, but it is in there, and at least it's an opportunity to, if you need Medicaid planning or other things, ability to do that in a guardianship with more clarity than we had before. We can now do what we used to call 867 trusts, court-appointed trusts. We used to call them for incapacitated person. We've changed that. There's still we can create a court-created trust for an incapacitated person, but we can also create one for a person who still have good cognitive function, so they're not incapacitated, but due to a physical disability, they need to create a trust. And generally, the reason they're doing this is they need it to be a special needs trust. So we have that. This is the first time we've had this. And two things I want to point out to you. Number one, the person can apply for it. The person that's physically disabled but mentally there, they can apply for it themselves. They don't need an attorney ad litem, so there's no need because they can speak for themselves. And it can be special needs. And a lot of the provisions of monitoring, monitoring through accountings and all of that, those are waived for these particular trusts. So this is really something a new tool that we have not had before that the Estates Code has now granted these individuals, which is really needed. I would just point out in the paper, we now have Texas Rule of Civil Procedure 21C, the privacy protection for filed documents. I don't know about you, but we got e-filing mandated in Harris County on January 1st. Just happened to be the same day the Estates Code came in. It was a great day in our office. It's not been the smoothest, so we're working through it, but it does. The good thing about it, it is a reminder, again, of all the things we have to do, and we can't file, and they're quick to kick back. But one of those things that we are all under, whether you have mandatory e-filing or not yet, and we're all going to have it eventually, is there's certain information that should not be in your pleadings and in your filings. Now, you have to reconcile this with some obligation under the guardianship sections, which you're supposed to have to file. So what I would tell you is this section does have an exclusion for that, but you better make sure it's really clear. One of the things in here is a date of birth of a minor. Well, in the guardianship sections, you might have to say an age, but you don't necessarily have to always say a date of birth. Be careful what you're putting in these sections and these applications as you're filing them, so you don't violate these rules, because it comes back to more and more lawyers are getting complaints and allegations for unnecessarily filing private information. So I just point that out to you. It's not a guardianship section, but you can't ignore it because it's going to come up in every guardianship filing you do in terms of accountings, financial information, and the first pleadings. Okay, let's talk about what our courts have done for us and to us. Good news, jurisdiction and venue. I think it's good news. We have for a decade had this sort of dislike and sometimes love of transfers and jurisdiction in probate courts. Went to the Supreme Court a couple of years ago as to what a specific guardianship court could have jurisdiction of as it relates to lawsuits involving the ward or specifically the guardian. And over time, there's been some legislatures who really don't like all these civil litigations, different lawsuits being filed and adjudicated in the same court with the guardianship. They think they should be over in the district court. So we have probably had 3 to 4 modifications of our transfer sections and our jurisdiction sections over the last decade, culminating the most recent definitions I was telling you about. Why does this matter? Well, just recently, the Houston Court of Appeals looked at a guardianship's jurisdiction and said, well, this is a case where the guardian was involved in a lawsuit involving real estate, and the lawsuit was filed in a county in South Texas. The guardianship was in Harris County, Texas. Well, under the general venue sections, that lawsuit involving real estate should have been filed in the county where the real estate was. That's our general venue. The guardianship court transferred the case to itself because it said, it's a case involving a guardian. And it went to the Court of Appeals, and they said, it's very nice that you have mandatory venue in that county, but venue doesn't matter if you have only one spot for jurisdiction, and that is in the guardianship court, because this is a guardianship proceeding, and this is a matter relating to a guardianship proceeding. Therefore, the Court of Appeals held that the transfer of that lawsuit involving real estate in another county where mandatory venue generally lies is properly in Harris County, Texas. So you can see this is the first time in about a decade where the courts have finally started going a different direction and upholding the jurisdiction of a guardianship probate court in terms of matters relating to a lawsuit where a fiduciary, in this case a guardian, was a member of. Other cases. Let's talk about the new case involving ad litem. It's a case of first impression. We talked about you have your court-appointed lawyers, and they have to take a certification. Well, this is the first time that a ward, I should say she was adjudicated to be a ward, so she's under a guardianship and representing her pro se, so you can kind of take this case for what you want. She filed an appeal of the order finding that she was incapacitated and therefore needed a guardian, and she also raised the issue of ineffective assistance of counsel. Now, in the past, that's generally been involved in criminal cases because of the Sixth Amendment rights. They've looked at those cases more seriously. And the court said, I'm not sure it exactly applies in this case because of the high threshold of a criminal case, but they're going to apply the Strickland standard anyways. And they looked at it, and in the end, they said the attorney did nothing wrong. They found that there was no ineffective assistance of counsel. But the point is, it's a reminder that everything about a guardianship goes under a microscope, including the quality and the efforts of an attorney ad litem. And I've been in, and I sometimes take very reasonable positions because I know that I'm advocating for that proposed ward, but I also know that the reality is I'm going to lose this case whether I spend, a few hours on it or hundreds of hours on it. It's just the way it is. So again, you want to do the best job you can for that person, and you want to do all you can for that person, but I caution you, this case out there. It's a case of first impression. And good news, it was one for the lawyer in this case. Let's talk about Rule 12 motions. Again, it's the idea of can a proposed ward or ward hire their own counsel when the issue is their capacity. Do they have the requisite capacity? Now, when you're a proposed ward, you haven't been adjudicated. So the law presumes you're competent. But in this process, you still have to show that you have the requisite level of understanding of hiring that lawyer. If a proposed ward hires a lawyer, the way you challenge the lawyer standing to represent, of course, this does not work on attorney ad litem, so don't try it just because you don't like them. But for terms of a privately hired lawyer, the way you challenge their standing to represent is a Rule 12 motion. It's got to be sworn to, it's got to be on file 10 days, and then you have an evidentiary hearing. It's going to be a little bit similar to these new provisions, I think, under the probate code. But it's interesting, in a Rule 12 motion, you can have a finding that the proposed ward did not have capacity, and this is what this case said, and it's an interlocutory order. So they can't appeal it until after the end of the guardianship. So I point this case out. It's the Benavides case, and they took it to the Court of Appeals, and they said no. And they also argued they're entitled to a jury trial, because in a guardianship contest, you're entitled to a jury trial on the issue of capacity, but you're not on these Rule 12 motions. And that's something that they had not ruled on before by any Court of Appeals. So Rule 12 motions, no jury trial, interlocutory, so you have no way to appeal it until the end of the case, which is effectively an order either appointing or not appointing guardianship. Benavides has been just a wealth of appellant decisions apparently in the last year or so, because there's Benavides 2 that just came out a few weeks ago. In Benavides 2, there must be a lot of money in this case. That's all I can figure to go to the Court of Appeals in less than 12 months and 2 issues. Benavides 2, the next person they knocked out of the case was the wife. First the lawyer, but apparently was hired by the wife, and the next was the wife, and it was another case on adverse interest. Now, adverse interest and disqualification are sort of the buzzwords in guardianship. Why? Because guardianships are a little bit the wild, wild west in terms of who can parties. There is no standing much of a threshold in guardianships. If you're the neighbor, you're the friend, you're the whoever, pretty much you can be a party to the guardianship proceeding because you have an interest in that person. Well, the way you get people out is either you have to be disqualified, so you can't be a guardian, but you have standing to still be in the proceeding, or if you have an adverse interest, that's not defined by statute, but some case law, then you can't even be a party. So really, it's sort of like you get all these people, but the only person that gets excluded from the proceeding is somebody with an adverse interest. So over time, case law has defined who is so bad, and I don't mean that in truly they're bad, it's just their threshold is so high, they should not be in the proceeding to either advance a guardianship, contest a guardianship, be involved, have a voice, have a say. And there's been very limited cases that have found somebody that has such an adverse interest. Creditors, obviously, are usually booted out as an adverse interest. In this case, it's one of the few where a wife was found to have an adverse interest. Now, admittedly, the facts are pretty good for the person seeking to find. She was challenging the prenuptial agreement. She was making claims to what was supposed to be his separate property, a community property. She was doing things behind the scenes. And the belief was she was just basically utilizing this process to try and get more property for herself, allegedly. But they found that she had an adverse interest, and therefore in this proceeding involving her husband, she was not allowed to be a party and advocate any position. And that's probably one of the strongest cases that have come down in a long time about what is an adverse interest. It's so new, I don't know whether they're going to file a PETA review or do anything beyond that, whether there'll be a rehearing, but for now, that's what it is. Okay, let's talk about a new case called Wynn that deals with the requirements of a hearing on an application for guardianship. Do you ever read a case and you say, I don't know what the Court of Appeals is saying? And then you read it again and you don't know what the Court of Appeals is saying. So I did what any good lawyer did. I made Chastity read it like 4 times. And she came back and she goes, I don't know what this case says. Why do I put a case in there that I don't know what it says? Because I want you to know about it. Because I don't know what this case really says. But it seems to imply that somehow you can have a hearing on an application for guardianship without a record, and maybe just they're going to let the pleadings speak to them, and that will be sufficient for it not to be on submission. I'm sure it's a combination of the fact that I don't know the underlying facts and the way the opinion is written, but I point this out because what does it matter to you? Well, it's one of the first. In the estates code, I'll keep saying probate code, in the estates code, you can pretty much have a hearing on submission on everything except contested matters and applications for guardianship. And they said there wasn't a hearing on this application for guardianship. And then they pointed out there was no record on this application for guardianship, which is suggestive of an oral hearing. And they basically said, no, the fact that there's no record doesn't mean there was wasn't a hearing. Now, after that, I don't know what you do with that case, but I'm pointing it out to you because if you have that situation, it's there. And we'll see if they do any modifications to that opinion. Okay, there's no area that had more case law in the last year than on the issue of attorney's fees. And here's the lesson. You'll get your fees if a guardian is not appointed depending on which jurisdiction you're practicing in. May you be in the one that you want to be in. Lidoffs and Witt are on page 17 of the paper. In one case, no guardian was found to be necessary. The jury found that the party moving for the fees shouldn't get their fees, and the court JNOV'd that and said, no, we're going to pay your fees from the proposed ward's estate because there wasn't a guardianship. In Witt, they said, you're not going to get your fees because there was no guardian appointed. I don't know. Again, 2 courts, 2 very different interpretations of the same section. So maybe one judge liked one lawyer better than the other lawyer. Maybe one court of appeals read that section. The section talks about that generally you're entitled to seek their fees, and it says in the bottom of it, the applicant is able to seek their fees whether he or she is appointed or not. I think one court read that to mean you still have to have a guardian appointed in general, even if it's not the applicant. And one court read that to mean if you don't win on the guardianship, you don't get your fees, period. But I point that out because there's very divergent opinions, and the new statutes are not going to change that. The last case is one I was involved in called Anderson McCormick, and somebody came along and purported to represent a guardian but was never hired by any order, did things that appear to be duplicates of what other lawyers were doing. And in the end, the underlying issue was not so much the guardianship, that was part of it, but was an issue of who was going to represent the guardian in a personal injury suit. And the court ultimately, we entered into settlement where the court was going to adjudicate the fees. She was not, or this person was not a party to that, and they felt like they were entitled to some of those fees. And so she appealed when the court finally said, you received X dollars, that's sufficient for the work you did, and she felt like she was entitled to some of those fees. So the point is, be very careful if you're seeking fees outside the application process that you have the requisite authorities, permissions of the court to represent the guardian in these proceedings, because this is one of those cases that it did matter beyond the issue of duplicate work, and it shows the great discretion granted to a trial court in allocation of fees as in these matters in guardianships. Okay, let's talk about, I've only got a few minutes left, so I am actually good. Let's talk about interlocutory versus final orders. There's a couple of new cases, Caton and Bellas, I think is how you pronounce it. And in Caton's, the issue was whether there was some orders dismissing certain orders and finding the court didn't have jurisdiction until an amended application for guardianship was filed. And one of the parties took that to the Court of Appeals and said, well, when you do generally orders of dismissal, those are final orders. But it's a reminder in the continuum of guardianship proceedings, and it equally applies to estate proceedings. You know, these are not like civil litigation where you have a filing, discovery, a judgment, and an end, and then we appeal. Guardianship proceedings and estate proceedings, but I'll talk about guardianships because that's my task today, is a continuum. And so what the Supreme Court has adopted is a test called Krausen, which basically says, you know, you look at the stage of the proceeding, and is it an end? Is that order to a logical end of that stage? And if it is, that order is appealable, because if not, you may never get to appeal an order out of a guardianship proceeding. A order challenging standing, granting an adverse interest, is a final order because it's at the end for that wife in that proceeding. Some fee orders are final orders depending on the wording in the order. But in this case, they said, even though we found the court didn't have jurisdiction, which in any other case would be a final order because it would basically terminate the proceeding, they said in this case, because the court kept jurisdiction due to the filing of the amended application, we are not going to consider that first set of orders final yet. With every one of these guardianship and probate orders, you really do have to parse through the cases to figure out what they consider an order to be final or interlocutory. In another order, they had an order appointing a guardian, and in that order it said, this dismisses or resolves all litigation. And they said that is a final order for purposes of appeal. So when they went back more than 31 days later and tried to revise the order, they said no, the amended order is void because the court lost jurisdiction even though it had jurisdiction over the guardianship. So keep in mind these cases when you weed through this process, you know, and we've done it on many occasions. We've filed a notice of appeal and we've had the Court of Appeals tell us that order is not ripe yet because it's the protection of you never know what a Court of Appeals is going to adjudicate certain orders to be along the way. Finally, in my last few minutes, I just want to point out these new pattern jury charges that we have. Again, we have never had any pattern jury charges as applied to estates and trust and guardianship. So the first tranche came out in last January. We are now the family and probate version of the PJCs instead of just the family version of the PJCs. It's the yellow book. And they are continuing to work on these. It's a great committee that works on these, has worked very hard, and so these are the first ones that are out there. I'll tell you that no Court of Appeals had vetted them yet, but every court I've been in has very much relied on them and has been quick not to deviate from their terms, believing they're well vetted, and I think they are. So now you have capacity, lack of capacity, both partial and total. You have both person and estate. You have a charge for best interest, which is sort of you still have to deal with the priority of the level, but a jury can decide based on somebody of equal priority who would be in the best interest. and you have charges for qualification. One of the issues has been, and it's recognized in the PJCs, is the issue of unsuitability, because the code says the court shall decide, but I will tell you the courts have inclined to submit all that to a jury, and that's reflected in these PJCs. And then there's new pattern jury charges on restoration and different levels, modification and removal of guardian. Now, removal of guardian is an interesting one because you're going to submit it, but usually the ultimate decision to remove or not remove, just like an executor, is in the discretion of the judge, but these lay the predicate for the judge making a determination whether removal should be done. Well, with that, I have finished, I think, a few minutes early, which could give Shannon a few more minutes to get going. And I very much appreciate your time, and Ashley and Riley including me in this program. Thank you all very much.